Good whenever this is. Everybody, like, subscribe, share if you like it. If you don't like it, then don't. But please do so. Share it with your animals, share it with anybody. Today, I was going to do a quick update on Alpine and the most recent brief that has been filed, and I can give you a schedule from this point in time. But before I start that, of course, and again, this is not legal advice. Don't rely upon anything that is said here, of course. Why did the egg hide? Of course, he was a little chicken. What did the pig put on his dry skin? Of course, ointment. And last but not least, or least but not last, what do you call a lazy kangaroo? A pouch potato. Anyway, talking now about Alpine, which is related to GTII. That matter is on appeal. The appeal concerns an injunction and an expedited attempt by FINRA to expel Alpine. Alpine was able to get an injunction from the appellate court after the lower court, the federal district court in DC, denied the injunction. This appeal is about that denial of the injunction. So the initial briefs were filed by Alpine. Then there were a bunch of opposing briefs filed by FINRA and other organizations that were similarly situated to FINRA. And those were called amicus briefs, Friends of the Court briefs. And on or about the 17th or 18th, so a couple days ago, Alpine filed its reply brief. And there may be, I guess there could be some additional amicus reply briefs, but those we don't know, and we'll have to see where that goes, and those would have to probably be approved by the court. So I have reviewed the reply brief, and I wanted to briefly go over what's asserted there, and then I'll give you a little bit of scheduling in terms of I've looked at the general scheduling in that particular circuit. So we are in the DC Circuit Court of Appeals, and I kind of did as much research as I could do in guesstimating the time frames for everybody. And by the way, so people think that if Alpine's out of business, that it might impact GTII, but it may just be the threat of Alpine being out of business that does the trick. And it may be a brief that's filed or a preliminary ruling that's given that might be that particular event that stirs the pot. But I wanted to just briefly go over what Alpine's brief is, what I think their major issue is if I were the judge, and then the schedule. So basically, again, they criticized Alpine's brief. It was interesting because they criticized FINRA's brief. They said FINRA and a bunch of other guys basically jumped on Alpine's back. In essence, that's what they're communicating. And they were asserting that nowhere in any of those briefs did anybody show why FINRA cannot comply with the Constitution. And the basic arguments, again, and we've heard these same arguments throughout in various pleadings, briefs that have been filed. One, that the appointments clause, in other words, the constitutional appointments clause, which impacts the exercise of executive power, would bar the judicial system of the SEC, FINRA from making rulings such as they are intended with regard to the expedited proceeding to expel. That's the proceeding that's also at issue. And that's the one aspect. The second aspect is that there's a non-delegation doctrine, basically so there's one doctrine that says if you're exercising basically executive power, the executive has to be the one who's appointing and removing. And the way the SEC and FINRA are set up, the executive branch has no input in terms of the judiciary of either FINRA or the SEC. That's a violation of the Constitution. That's what the claim is. The second major argument is regarding the non-delegation doctrine, which is a doctrine that says that you can't delegate to private entities certain types of functions. And this is one of the functions they're claiming you can't delegate. However, the appointments clause is the major argument that's made by Alpine. The non delegation is the secondary argument. And again, it's just solely as to the expedited proceeding. So there have been numerous actions between Alpine and FINRA and the SEC since 1984. It just came to a head in 2023 when, in or about April, uh, Alpine, the SEC and FINRA tried to do an expedited removal of Alpine. That was the change. And that's the proceeding that Alpine contends is requires constitutional protection because there's no due process. And then additionally, the other issues are the judicial issues about who should be appointing the judges that handle the SEC and FINRA matters and whether those duties can be delegated at all. So, but again, it's the fast nature of the relief that is sought here that's the compelling reason. And there's no exception, they say, for just because something's not delegable doesn't mean that the appointments clause wouldn't apply or vice versa. So they say in essence one argument may not survive, but the other argument might prevail. They also say, that fact that FINRA claims the sky is falling, that if all the regulatory system fails, that will be the end of the universe. That's the same argument they make in every case, and just ignore it. Then they go to the part which I think they have a problem with. I don't really have a problem with a lot of their argument other than their conduct. But then they go to the equitable side. And again, since this injunction is involved, it's an equitable claim. And you have to balance the equities in terms of when you grant or deny an injunction. And you also have to establish irreparable harm. In other words, harm that would be occasioned by Alpine that you could not correct. And Alpine says their argument is if there's an expedited expulsion proceeding, that will cause them irreparable harm. Now, I disagree with that because they could win the proceeding. Number one, there's appeals of that proceeding. They could take that proceeding to court. So I disagree with their conclusion that there would be any irreparable harm. And if I were the judge just on that basis, I would deny the appeal because again, the appeal is supposed to be as narrow as possible. So as opposed to deciding these grand constitutional issues, if you can decide it on narrower grounds, for example, that someone's just not entitled to an injunction just based on the facts, that would be the way that the case, in my opinion, should be decided. So one issue is no irreparable harm, because just because the court denies the injunction doesn't mean that the proceedings can't go on. There has to be further hearings, and they could prevail at the hearings, or they could prevail on the appeal, or they could take it up to federal court. So I do not see any irreparable harm. Therefore, Alpine loses. That's one. And anybody who's on the short side, I think you should consider that. Two, is the benefit to the public. Alpine asserts that it benefits the public, that they're protecting the constitutional rights of everyone. In my view, Alpine has been a risk to the public at all times. They've engaged in illegal, tortious, dangerous, potentially not only illegal, but maybe even terroristic activities. We know they had many violations of the Bank Secrecy Act. We know that Binance was recently, last couple of days, last few days ago, there was a plea deal because of one of the aspects being a violation of the Bank Secrecy Acts, which was related to potential terrorism and money laundering. Well, Alpine is subject to the same kind of issues. I don't have firsthand knowledge, but I know they've been on appeal. They lost and were penalized $12 million for thousands of Bank Secrecy Act violations. So I don't see how that's a benefit to society, whether they are meaningful trying to propose and support constitutional arguments of the public, I think their very existence is a danger to the public. So therefore, on the equitable arguments, I think they lose. So if I'm the Court of Appeal, I would just ignore most of the constitutional provisions. I'd go right to the equitable arguments. I'd say, I don't think you've established irreparable harm, and I also don't think you've established the benefit to the public. And if you can't establish that, then we don't have to go into the constitutional arguments. That's the way I would decide it. And if they wanted to pursue the constitutional arguments, I'd let them go through that expedited hearing, see how it went, file whatever appeal, see how the appeal went. And then if they needed to take it up in the federal court system, that's when I would deal with them. But they have other remedies before they would ever get to that. That doesn't change my view that eventually they'll be kicked out. Okay, so that's my view. And somebody reviewing the briefs and reviewing where the case is now may come to the same conclusion that notwithstanding whatever their claims are, and at this particular moment, I think as to the injunction, they should lose because they haven't established the necessary elements to prevail for that injunction, in my opinion. Now, when will this be decided? So the last brief apparently was filed, or it's on the court docket as of November 17th. Looking at the general category of when matters are heard, it'll be approximately 3 months to the oral argument, which would make it sometime probably in February, and approximately 3 months for a decision after the oral argument. So let's say sometime towards the end of the second quarter. I think I was guesstimating those numbers before, but I kind of happened to do some research on it today. And those were general median numbers. So 50% of the cases were faster, 50% of the cases were slower. I noted that the time from filing to when the briefs were all submitted seemed to be a little faster than normal. So perhaps this will go faster. But it may be the case that long before the case is even heard or decided, that other people have made their own decisions as to how they think it will go. And of course, there's another case going before the US Supreme Court involving just the SEC only, with some of the very similar arguments in Gtii. I think that is set for oral argument next week before the US Supreme Court. And the outcome of that, theoretically, could impact the outcome of the Alpine case. But again, in my reading, Alpine should lose this appeal. My opinion. They should lose the appeal. They haven't satisfied the equitable requirements. That's something I've mentioned before. And when reading the briefs and reading their last argument, because they argued about the equities at the very end, I think this is a weak argument for them. So that's the way I see it. Hopefully others will see it the same way or not. Anyway, be well, take care. More to come later at another time.